Shea Brown and Nicholas Robinson. Anybody in the courtroom on Zoom video? Do I have Nicholas Robinson?
Yes.
All right, good morning.
Morning.
And I understand we also have Shea Brown. All right, good morning. Go ahead and step forward if you would, please.
Sorry. I'm really sorry. All of my evidence disappeared and I had to get it in different ways, so we're not. I do have a lot. The other request I have is maybe.
Well, go ahead and step forward because he can't hear you if you're back in the back of the courtroom. You need to come on forward
Yes, sir.
so both parties can hear and have a seat. That'd be fine right there. And is it pronounced Shea or Shea?
Shea.
Just like Shea Stadium.
Shea Boulevard, Scottsdale.
All right, very good. Good morning, both of you. In this matter, it's before the court on a request for domestic violence restraining order. And Mr. Well, let me go to Mr. Brown. Ms. Brown, are you ready to proceed?
Honestly, I should be, but there's been really weird stuff going on and I lost like half of my iCloud worth of 2 years of evidence. But I do have every most critical court report for him where he's criminally charged or acknowledged. And then I also have like psychiatrist notes while I was with him. And then I can't find the Verizon. We had basically something wrong with our phones and Verizon even acknowledged that it wasn't right. So I had to change my phone numbers and I don't know what's going on, but yeah, we have evidence more than this. I don't know if we need a trial or not, but I have so much.
Well, let me explain how it works, and I'll go also to Mr. Robinson in just a moment. Well, let me ask, Mr. Robinson, are you ready to proceed to trial?
Yes, but I have a few things I need to discuss. For one, I showed up on July 2nd, thinking that that's when the hearing was, and the judge told me, only the judge in there told me that it was rescheduled till today. And the judge, last time I saw them on the 2nd, because I didn't know it got continued, told me that she had to serve me notice of this continuance.
Well, she may not have.
Right.
I have the original proof of service indicate, well, let me back up. I have what is a proof of service by mail of the request to continue the hearing, indicating that it was mailed to you on July 15th. However, beyond that, let me go deeper into the file and see what else we have.
I also have another one too. I have 3 actually.
I never received any mail via physical or email. I don't have a physical mail address, and nobody
says
ever.
There was a proof of electronic service that was made on or about July, should say June 30th, 2025. I'm not really seeing a actual proof of service.
I have a few, sir.
Do you have a proof of service with you today?
Yeah, and let me give you some context. Like, I love that you gave me that order. It was a super huge sign that you were listening, and I appreciate that for the record. I really do. You have no idea how hard this has been. But I had to go to a couple different situations. Nobody could give me an answer on how to serve him exactly. The women at the front desk didn't even give me the proper service form for electronic service at first. So I spent hours trying to figure this out. And I did have an attorney that helped me. Pretty much what he said was that basically the only address that Nick's had since, you know, we went homeless is because like it was our old house. And so he tried to at least send it to the management and our old unit as well. I have proof of that right here. And then I have proof that Justin also did a email proof.
Let me stop you there because I think I see what's happening here. You're having difficulty having a process server personally serve him with the papers.
Well,
Is that correct?
Yeah, I think that's why you ordered the whole order, if I'm not mistaken. Also, he acknowledged he's seen it. He's on camera talking about it.
But it's very clear that there is a requirement in these types of cases that a person has to be personally served, unless a special application is made to the court for an alternative service.
You chose that, sir.
Let me take a look at what you have. Give me a moment. I'll look at it.
Yeah, and I thought it was a godsend, just for the record, but I didn't ask for it, but I needed it.
Just that one page. I hand
Oh,
that
the
to
top
you.
one, okay.
And you're not here, Mr. Robinson, so I'll try to keep you updated on what I'm seeing. No, this isn't it.
Wait,
Hold on just a moment.
Oh, no, this is it right here. Sorry, I'm so sorry. So much stuff.
This is the order on the request to continue the hearing.
My bad. I had them mixed up. I'm so sorry.
All right. And this is the same thing.
Wait, really? It should say that the order is right there on it. The style. I had the front desk and the paralegals look at it. I was here for hours. I've lost work trying to make sure this is like, I have to have, I'm really, there's a reason I'm doing this, trust me, and I wouldn't be working this hard. And I spent hours trying to figure that out and nobody could get, I mean, I went to the administrator's office. I went to the paralegals at the self-help center. I went to the front. I Googled it. We had attorneys try to figure it out. I mean, we did beyond our best with this one, if I can be frank. And I have, like I said, he was mailed both through social media, also through regular mail, and then also through his 2 emails that he definitely gets.
I've never received any emails.
I was told by the front
Oh,
desk.
no, I have to have one at a time. Let me wait just a moment for both of you.
No worries.
I'm looking at the order from Judge Hayes on June 30th, 2025. And I'm going to verify it by looking at the actual one in the file, indicating that it says that you must have the restrained party served with a copy of this order. This can be done by mail. You must serve as soon as possible. It also checks other, must provide verbal and/or electronic notice. So it sounds like there was an attempt to make electronic service.
A variety of attempts, yeah.
And Mr. Robinson, you are saying that you did not receive anything, is that correct?
Improve.
Yes. I don't even know which of my email addresses she says that she had or sent it to, but they might be old ones I don't have access to. And regardless, when it comes to emails that I do have access to, I haven't received anything there either. And no papers in person, anything like that.
I have him on camera mocking the case somewhere in my evidence.
All right, give me a moment. Did you ever give him verbal notice?
Yes, as well. Yep, I did it over, I asked everyone and they said, okay, if you at least say it over, like, because we're both YouTubers. So he also acknowledged it many times. And so with his.
Well, when I say verbal,
Your
you
Honor.
hold on, Mr. Robinson.
We
You say
don't
you
have
talked to him
contact.
personally?
We don't have contact info, but he talks to me through the internet for sure. It's the complexity of this case, if I may be frank.
All right, I'm not going to find sufficient notice today, one. And two, this is going to take a far more time than we
might,
can
yeah.
take on today's
Okay,
calendar.
okay.
We're limited to 20 minutes,
Yes,
and this
I
is going to
agree.
take a lot more than that.
Okay, yeah.
I can
good.
set it for trial, but
Okay.
again, you're going to have Mr. Robinson served.
He
Mr.
doesn't know right
Robinson, is
now.
there a way that you can be served or get these papers? What are your thoughts?
I mean, she was able to serve me with the initial DV hearing when this all began. You know, in the beginning with somebody in person. I don't always have access to email. I make sure to not give her my email address. And also, I'm wondering, is it possible to file just a motion for dismissal?
Well, that's what a trial is, really.
All right.
In these types of cases, you have the trial. In this case, the court did not issue a temporary restraining order, so there are no existing orders
That was a
right
sad
now.
mistake, but they
And you have a
retaliated.
trial, if the judge finds sufficient evidence, he or she would issue the restraining order. If the court finds that there isn't sufficient evidence, then the court would deny the restraining order. It's pretty much that simple.
I do. Oh,
If you'd like, I can just set the trial date today. It'll be a few months
that's
off.
fine. Okay. That's fine.
And you can waive notice, Mr. Robinson. If you got the initial papers, the following papers really only give you the new court date, which I can give you today.
Yeah, that works.
So you waive further service of the papers up to today, is that correct?
Can you clarify what that means?
Well, in other words, you say you got the initial papers, is that correct? Her request for the
Yes, but-
restraining order?
No,
Yes,
sir.
at the request. This continuance papers and discovery I have not received.
He's also admitted to wanting to.
Well,
renovate.
there may not have been any discovery at this point.
Okay.
Yeah, no, I have.
If you have
more
it,
than
she
just
has
this. Would you like to look at some of it?
no,
Okay.
not today. Today's not the trial. And I can't look at things if I'm going to, if you're not going to have the trial today.
I did have a
So I'm
request.
simply going to do this. Mr. Robinson, if you've waived notice of this hearing for today, I'm going to set her for trial. If she has further discovery that I can order that she give to you, how can she best give that to you?
I mean, it works best when the guy physically gave me the papers. So if she could just have a process server come serve
It
it.
doesn't work that way.
Does
He knows
she
that.
know where you are?
No, he knows.
I am in social media. She actually, I have no way of communicating with her or talking to her like she claims. She stalks my location, so she always knows where I am.
Mr. Robinson, let
always
me
asking-
stop you for a moment. Ms. Brown, don't
Yes.
talk while he's
Sorry.
talking.
No, I'm sorry. He
But
just
you
forwarded
have
me.
a
I
habit of
approve.
doing that even right now.
I'm sorry. No, I approve of
Just
it.
don't say anything for a few
I
minutes.
apologize.
All right. Mr. Robinson, I apologize. Go ahead.
So she's certainly able to know where I'm at. She's proven time and again to basically track my location down. That's how she served me with the additional papers. So she can do that again.
All right, let's get a court date and then we'll figure out how to get the discovery both ways. If you- if-
A request, he did waive discovery the first hearing for this exact reason. Also, he's literally like closer to me than he was before. He got pushed out of Isla Vista.
We'll talk about that in a moment.
Okay.
Let's get the court date, because that'll tell us a little
Okay.
bit about how much time we have.
So then he doesn't.
I'm going
serve
to
for
estimate that this can be done in one day. Is that correct?
Yeah, without a doubt. And that's with CrossFit.
Mr. Robinson, would you agree?
Is that when the next date's going to be or the trial?
In
or
other
what?
words, when we put the trial on, you can get it finished in one day. It's not going to be a 2 day.
I'll draw it out.
Right.
All right, yeah.
Be planning
All
on.
right, so let's get the next available 1 day trial for a DV.
Oh,
September 4th. Does that work for each of you?
I have a request, but you can let him answer first.
Well, if you can't do it, let's start with you, Miss.
The reason that I'm worried is because the reason I was hoping you could at least glance over some of this is because maybe there was a way you could reinstate some kind of emergency order. It's unfortunate. He has active warrants for DV in Arizona. He also is committing cybercrime.
No, I'm going to put it on September 4th if that date's good for you.
It would be, but I don't want to wait that long while his viewers are stalking and harassing us.
I'm not going to go back over the temporary order that was
Is
denied.
there anything in place of that?
No, because that would be a trial if we wanted to present evidence. Mr. Robinson, does September 4th work for you?
Yeah, that works.
All right, we're going to set it for September 4th, and that's going to be at 8:30 in Department 120, I believe. The clerk is agreeing. It'll be Department 120. That'll be September 4th at 8:30 in Department 120 for a 1 day trial. Now, that gives you each time to get the documents that you're going to present at trial to the other party. Each of you need
Excuse me.
to
No. it's not
serve
happening.
any documents or other evidence that you're going to present and a witness list to the other party. At least we'll make that 2 weeks prior to the hearing. So that'll be September 4th. So we'll make it no later than August 21st. That gives you each a month to do it. You can try to get it done right away.
Oh, I'm so confused,
Miss,
I'm not gonna lie. But I just don't know what's going on. I'm trying to figure it out.
Well, Ms. Brown, you just need to get anything that you're going to present to the court on
Yeah.
September 4th. Get that to Mr.
He will
Robinson.
not know, sir. What I'm saying is that all order was a gift. It was intentional he's also had a person come and stalk the room. I have all the evidence. No one's taking it. I have the video of his viewer, Melissa. She is supposed to be in here right now. She had posted your face on YouTube, by the way, in a threatening manner. There's a lot going on here and it's not good. And we're getting punished for it. Me, my roommates, my friends that are good to me, anyone who stands up for me.
All right. I can only make the order today, and that's what I'm going
Can
to
we
do.
make it in alt order so I can at least be sure to, can he give you an email?
Hey, hold on. Mr. Robinson, yes, go ahead.
I'm sorry to interrupt. Though. Can you tell me exactly what time on the 4th? There's a truck going by, so I couldn't hear it.
Yes, 8:30 on September 4th. And
Thank
that'll be. And on a trial, you do have to be here in person. The clerk is just asking me to remind you that.
So there's no way to do this on Zoom.
No, you'd have to.
So
you'd
is
have
there
to be in
is there a way
person.
to not have a trial? Just keep doing it on Zoom?
No, unless I just grant her the orders that she's requesting, and I'm not sensing that that's what you want to do.
No. So in order to beat this, I have to show up in Sacramento on
Right,
the 4th.
That's correct.
Can we?
Well, let
is there
me state this. You can apply to the court to appear remotely, but I'm not the judge that would be making that determination. But at this point, the court would be ordering you to be here in person on that date.
If that's the case, can I get it pushed back, possibly to a later date, so I could have the means to actually make my way out there and be present? Because I'm far away and I need to have sufficient time ahead to make the reservations go out there.
He has money. He's
No,
made money off
I'm going to leave it on for September 4th. So again, I'm going to have to move on to other cases now, especially since all we're doing is setting a trial today. So the court is going to set it for September 4th at 8:30 in Department 120. Both parties will need to be present in court on that date. And you'll need to disclose any documents or other evidence and witness lists to the other party no later than 2 weeks prior to that date.
An email is okay or no, because that's the only way he's gonna be, he's making jokes about this.
Will you
I-
accept email, each of you, for the discovery, Mr. Robinson?
I have no way of knowing when I'm gonna have access to the internet or not.
All
I
right, then I'm
prefer
going to,
personal.
I'll require each party just to do whatever he or she can do to get that discovery to the other party. All right, and that's all I can do for
Can I
today.
just clarify on that? Is that okay if I post it on YouTube and tag him? Because he's on there every day.
I'm not going to state that at this point, you need to get the discovery to the other party. All right?
Okay.
That's how it's going to be.
Okay.
Thank you both.